Everybody, this one is about the Roman cult slave scam. Step one is this happened back in like the 1500s. But anyways, redefine the nature of the contract with private international law. And this is a Wikipedia webpage about a guy by the name of Alberico Gentili, was the earliest writer on public international law and the first person to split secularism from canon law. So it's all coming from canon law from the Roman cult. And so he was a Regius Professor of Civil Law. That's the point I want to make, is that it's all coming from the Roman cult. And he was Italian lawyer and jurist, and anyways, so that'll get us going there. Step two was the War of Independence. Okay, the Roman cults bought and paid for Satanist King George III becomes a tyrant and enslaves the colonists under their Roman law, and the colonists rebel, creating the War of Independence. And this is the definitive Treaty of Peace of 1783. And it says here that King George is King of England and France, which means that he financed both sides of the War of Independence. And he is Arch-Treasurer and Prince-Elector of the Holy Roman Empire and the United States of America, which means that he's using Roman cult money. They wouldn't mention it unless it was important. He's using Roman cult money to finance both sides of the War of Independence, and that's why the judges, the federal judges nowadays, will say they get instructions from England, and that's true because Queen Elizabeth is now the successor to King George III. And so Queen Elizabeth is our treasurer and prince-elector of the United States of America. And so, like a friend of mine says, oh, what a tangled web we weave. This is the causes and necessities for taking up arms. 1775, statutes have been passed extending the courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, instead thereof to publish an order and use the exercise of the law martial. Okay, and so they were assaulting them with their Roman law, this martial law, and it's actually martial law rule. And we'll talk about that further on. We saw the misery to which such despotism, that's dictatorship, would reduce us. And that's the causes and necessities for taking up arms, 1775. When King George assaulted the colonists with the Roman cult satanic Roman law, he breached the peace. He breached the trust. And when Franklin J. Adams and Hartley signed the so-called treaty, they perjured their oaths because they made the criminal act of King George III legal under their satanic international law. The definitive Treaty of Peace of 1783 is a fraud and a nullity. The definitive Treaty of Peace converted criminal activities by King George into a contract. With the Roman cult, there is no peace. It is constant commercial warfare. Now, I want to make a little disclaimer here because I'm going to say a lot of things about the Roman cult, and I don't want anybody to think that I'm talking about anybody that happens to be Catholic. Some of my best friends happen to be Catholic, and a lot of them are telling me about this stuff, and then I do a little research and put it all together. So this is not meant to be construed to say anything negative about anybody that happens to be Catholic. Step three is create the bankruptcy scenario. So King George III was King of England and France. He financed both sides of the War of Independence. King George III and his predecessors and their Roman cult handlers deliberately made things so tyrannical that people were leaving in droves. Remember, people were leaving. It was a tyranny in England. They were leaving for anything, get anywhere but out of England. Queen Elizabeth, the bitch, is George's successor. And this is the Carolina Charter of 1663, yielding and paying yearly to us, our heirs and successors, for the same the yearly rent of 20 marks of lawful money of England at the Feast of All Saints, yearly forever, the first payment thereof to begin to be made on the Feast of All Saints, which shall be on the year of our Lord 1665, 1665, and also the fourth part of all gold and silver ore, which with the limits aforesaid shall from time to time happen to be found. And so they want 20 marks of lawful money of England, okay, which is that was gold, and I'm not sure how they measured that. But they also wanted a quarter of all the gold and silver. And that continues to this day, and you'll see. That's taken from the Carolina Charter of 1663. And this is a map of the Carolina Charter of 1663. The dark one is in 1663, and then the lighter one is in 1665. So, you know, that the thieves like to change their rules, too. And you don't think that the same kind of thing was going on for the rest of the charters? I mean, Pennsylvania. The reason it's called Pennsylvania is because the king granted it to William Penn. You don't think that they went and put that kind of stuff in there? Of course they did. This is the Declaration of Rights of 1776 of the North Carolina Constitution. And provided further that nothing herein contained shall affect the titles or possessions of individuals holding or claiming under the laws heretofore in force or grants heretofore made by the late King George II or his predecessors or the late Lords Proprietors or any of them. Okay, so they're basically reaffirming all of these fraudulent contracts. Okay, that's what they are. And this is the treaty between the king and the 13 colonies of the United States of America, signed at Versailles, July 16, 1782. And it's agreed, Article 1, it's agreed and certified that the sums advanced by His Majesty to the Congress of the United States of America on the title of a loan in the years 1778, 1779, 1780, 1781, and the present 1782 amount to the sum of 18 million livres, money of France, according to the following 21 receipts, as above mentioned, under written Minister of Congress, given in virtue of his full powers to wit. And basically it goes through all of the installments that were made in those years. Anyways, this source is Treaties and Other International Acts of the United States of America, edited by Hunter Miller, Volume 2, Documents 1 through 40, 1776 to 1818, Washington, Government Printing Office, 1931. So you can't tell me that Franklin and Jay and Adams or Hartley or any of the founders of the day did not know that King George III was the King of England and France, okay? They absolutely had to know, okay? That's any brain-dead idiot would probably have known. The founders were all Masons on top of that. Because of this, King George became Arch-Treasurer and Prince-Elector of the United States of America. They should have said, screw you! Therefore, some of the founders were in on it, obviously. In Tarrant versus Taylor, it was stated that the dissolution of the regal government no more destroyed the rights of the church to possess and enjoy the property which belonged to it than it did the right of any other corporation or individual to his or its own property. In the latter case, the Chief Justice, in reference to the corporation of the college, observes that it is too clear to require the support of argument that all contracts and rights respecting property remain unchanged by the Revolution, and the same sentiment was enforced more at length by the other judge who noticed this point in the cause. And this is the Society, etc., versus the town of New Haven at 8 Wheat 464, which is like probably in either the late 1700s or the early 1800s. Anyways, the point being is the Revolution didn't do anything to affect, these alleged debts. There are two ways to conquer and enslave a nation. One is by the sword and the other is by debt. And so step 4, the bar member infiltration. The leaders of the War of Independence knew the threats that bar members were to anyone wanting freedom, and they repeatedly tried to make sure that bar members were prohibited from holding any position of trust. See Bar Members 1, 2, and 3 videos. All bar members are foreign agents of the Roman cult and BAAL priests. The Roman cult needed their bought and paid for bar members to infiltrate to accomplish the rest of the things named herein. And we'll go through all of the stuff that these bar members have done. This is the Articles of Confederation. Nor shall any person holding any office of profit or trust under the United States or any of them accept any present emolument, office, or title of any kind whatever from any king, prince, or foreign state, nor shall the United States and Congress assemble or any of them grant any title of nobility. So they were trying to do it here in the Articles of Confederation. That's Article 6. This is the Constitution for the United States of America, Article 1, Section 9, Clause 7. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of Congress, accept of any present emolument, office, or title of any kind whatever from any king, prince, or foreign state. And that's, so that was their next attempt. And this is the real Article 13 an amendment, which was taken from a 1819 Constitution, taken from Virginia statutes. This same amendment was also found in Colorado statutes in the taken from the 1850s. Anyways, it says this is like this is one that did it, and we'll talk about that more. But anyways, it says if any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, okay, or shall without the consent of Congress accept or retain any present pension, office, or emolument of any kind whatever from any king, emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them. And that's what did it, okay? Because they're receiving an honor, at a minimum an honor, and a title of nobility is correct too, actually, and it's from a foreign power, okay? And so step 5 is they needed to disappear that Article 13 an amendment, okay? So that's what the Roman cult was up to next, the War of 1812. The major engagement burned the National Archives in the Capitol. The true Article 13 amendment found in the Constitution that shown here is from 1819 Virginia statutes. The true Article 13 amendment found in the Constitution taken from 1850s Colorado statutes. The Crown and the Roman cult needed their bar member Baal priest to infiltrate, and the Roman cult hired the War of 1812, and that's exactly what happened. Step 6, infiltrate Roman cult bar members and seize control, and so they create unconstitutional municipal corporations. We're going to talk about that later. They put municipal corporations deeply in debt. They seize them in bankruptcy. They seize the courts, and it's the same procedure that precipitated the War of Independence. Step 7, Roman cult bar members convert citizenship into the opposite of what is intended. And this is Colgate versus Harvey, U.S. Supreme Court. And while the 14th Amendment does not create a national citizenship, it has the effect of making that citizenship paramount and dominant instead of derivative and dependent upon state citizenship. So they turned it into the opposite of what the Founding Fathers intended. And this is affirmed by United States versus Rhodes. The amendment reversed and annulled the original policy of the Constitution. And the so-called 14th Amendment is unconstitutional video. It goes through and explains it's actually a revision. The Roman cult bar members circulate fake money under their Roman law. At common law, only gold or silver, legal tender. The forced loans of 1862 and 1863 in the form of legal tender notes were vital forces in the struggle for national supremacy. They formed a part of the public debt of the United States. So those are bills of credit is what they are, and they're unconstitutional under the Constitution. But that's what they did, and that's one reason that the 14th Amendment's unconstitutional. Anyway, step 9. The Roman cult bar members create unconstitutional municipal corporations. The governments are but trustees acting under derived authority and have no power to delegate what is not delegated to them. But the people, as the original fountain, might take away what they have delegated and entrust to whom they please. The sovereignty in every state resides in the people of the state, and they may alter and change their form of government at their own pleasure. And but they have no authority to delegate. There's nothing in there that says in the Constitution that says anything about municipal corporations. A delegate cannot delegate. An agent cannot delegate his functions to a subagent without knowledge or consent of the principal. The person to whom an office or duty is delegated cannot lawfully devolve the duty on another unless he be expressly authorized to do so. There is nothing in the Constitution that talks about any kind of corporation, actually. Anyways, these are maxims of law. A delegated power cannot be again delegated. A deputy cannot have or appoint a deputy. So state statutes are actually federal statutes, and that's because of these municipal corporations. International law rule adopted for areas under federal legislative jurisdiction federalizes state civil law, including common law. The rule serves to federalize not only statutory but the common law of the state. The civil laws effective in an area exclusive federal jurisdiction are federal law, notwithstanding their derivation from state laws, and a cause arising under such laws may be brought in or removed to federal court under sections 1331 and 1441 of 28 U.S.C. Anyways, this is taken from Jurisdiction Over Federal Areas Within the States, Report of the Interdepartmental Committee for the Study of Jurisdiction Over Federal Areas Within the States, Part 2, a text of the legislative jurisdiction submitted to the Attorney General and transmitted to the President June 1957. And that's basically a summary over page 158 to 165. There has been, that's not a summary actually, that's a text that was taken from it, but there's some things that are obviously left out. Anyways, and there has been created a fictional federal state of XXX within a state. See Howard versus Sinking Fund of Louisville. That's a U.S. Supreme Court citation, and it's being cited in this Schwartz versus Harris Township School District. And good load of this, Indiana and Company. Let's see what it says. 3,460,000 stockholders engaging in providing peace, justice, security, opportunity, health, highways, education, conservation, recreation. This is actually, anyways, it goes on. There's a certificate. Every Indiana citizen is a stockholder in 4,300 school buildings, 9,168 miles of highways, 34 state parks and memorials, 19 state institutions, 4 colleges and universities, state library, state fair, and is entitled to services rendered by all state departments such as police, courts, health, securities commission, public service commission, social security, conservation, industry and labor services, insured bank deposits, and life insurance policies. This certifies that every Indiana citizen is the owner of a full share of the capital stock of Indiana and Company. Says transferable only on the books of this corporation is express on, and I'm not sure what the rest of it says. Anyways, it is signed by the governor in 1938. And what this is taken from the report of the fiscal year beginning July 1st, 1936 and ending June 30th, 1937, prepared by the Indiana Gross Income Tax Division. And so there's one of the municipal corporations. You don't think they're set up in every other state? Of course they are. Step 10. Roman cult bar members put these municipal corporations into bankruptcy. And this is U.S. Congressional Record, March 17, 1993. It's an established fact the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt, being bankrupt and insolvent. And HJR 192, 73rd Congress in session, June 5th, 1933, joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacities of all United States governmental officers, and departments, and is further evidence that the United States federal government exists today in name only. Yet still it was found difficult to set bounds to ecclesiastical ingenuity, for when they were driven out of all their former holds, they devised a new method of conveyance, by which the lands were granted not to themselves directly, but to nominal fiefs, to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profits, while the season of the land remained with the nominal fief, who was held by the courts of equity, then under the direction of the clergy, that reads Roman cult, to be bound in conscience to account, or tax, to his sestique use for the rents and emoluments of the estate. And it is to these inventions that our petitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. So what we're talking about here is this is all created by the Roman cult, okay? The courts were under the control of the Roman cult. It was the Roman cult that did it, and taxes are all going to the Roman cult, and it's the foundation of modern conveyancing. In 1835, you don't think it's happening today? Of course it is. Step 11. Through bankruptcy process, Roman cult imposes martial law rule. And so we're under martial law. There's three kinds of martial law: full martial law proper, and martial law rule, which is the law of emergency and necessity. And that's taken from Ex parte Milligan, 4 Wall 2, which is, that was like around the Civil War time. And that's also found in Diet versus Turner, the non-ratification of the 14th Amendment by Judge A.H. Ellett, the Utah Supreme Court. So full martial law, so we know what we're talking about here. Full martial law is declaration of martial law is issued. Troops are put on the streets, used only during wartime. It's used on a foreign country or when actually invaded by a foreign power or to put down an armed rebellion. Okay, and so that's what full martial law is. Martial law proper is the law of the armed forces. When a captain tells a private what to do, enforced by court-martials. And again, that's taken from that Diet versus Turner case. Martial law rule is the law of necessity and emergency. Allows the domestic use of martial law powers and is used during peace times. And that's what we've been under since at least the Civil War, for sure. Evidence of martial law rule. Military script is circulated for money. The action of Congress on the passage of the first Legal Tender Act was placed distinctly upon the ground of the existing imperative need of the government, and the Legal Tender Clause was urged and adopted as a war measure. Okay, martial law. Juilliard versus Greenman, U.S. Supreme Court, 1884. Evidence of martial law rule. Police wear military uniforms. Military script is a forced loan. The forced loans of 1862 and 1863 in the form of legal tender notes were vital forces in the struggle for national supremacy. They formed a part of the public debt of the United States. That's again Juilliard versus Greenman, 1884. U.S. Supreme Court. So, and then since March 9th, 1933, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and a plethora of particular ways control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule for 40 years. Freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. And that's taken from the U.S. Senate Report number 93-549 dated November 19th, 1973. And the interesting thing is that this is March 9th, 1933 when that happened. Now let's go back here when the bankruptcy happened. Right here. March 9th, 1933 is when the government get bankrupt. Okay, so martial law and the bankruptcy work hand in hand. Bar members have brought us martial law rule as described in the presentation on martial law. And this is taken from the Revised Code of Washington, Section 1.16.090, Legislative Declaration for Civil Liberties Day of Remembrance. The legislature recognizes that on February 19, 1942, the President of the United States issued Executive Order 9066, which authorized military rule over civilian law and lives. So it's all been martial law rule. And that's all brought to you by bar members. Roman cult bar members have facilitated the imposition of martial law rule. Congress, claiming its martial law power to declare war, suppress insurrections, and repel invasions, imposed martial law in the United States and never discontinued it. The result was an extension of military and municipal jurisdiction of Congress, but where's the evidence of this? Look at the 13th Amendment, the Civil Rights Act, the legal tender laws, the 14th Amendment, etc., etc., etc. And that's taken from Diet versus Turner, the non-ratification of the 14th Amendment by Judge A.H. Ellett, Utah Supreme Court. And this is the same thing that was going on that precipitated the War of Independence. This is taken from the causes and necessities for taking up arms. Statutes have been passed extending the courts of admiralty and vice-admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property. To supersede the course of common law, they want to get rid of that nasty little common law problem so they can just do whatever they feel like doing. And instead thereof to publish and order the use and exercise of law martial, and for altering fundamentally the form of government established by charter, we saw the misery to which such despotism would reduce us. And again, that's causes and necessity for taking up arms, 1775. So martial law and bankruptcy happen concurrently. For more information about martial law, see the Martial Laws Here video. Step 12, the Roman cult seizes the corporation masquerading as the government. And this is AMR creditors prefer all stock merger with U.S. Airways. And if you go to the highlighted part, it says, as the new owners of a significant percentage of the restructured airlines, it's APA's responsibility to maximize the value of our investment by conducting thorough due diligence. Pilots Union President Keith Wilson said in a message posted on the union's website on Wednesday. And so, again, when any corporation goes bankrupt, the creditors become the owners. Under U.S. Airways proposal sent in November, AMR creditors would own 70% and U.S. Airways shareholders 30% of the merged airline, which could be valued at around $8.5 billion, sources told Reuters on Friday. So again, the creditors, when a corporation goes bankrupt, the creditors become the owners. The stock becomes worthless. In this case, the shareholders obviously had some equity that was in there, so they got 30%. But otherwise, it's many times when they go bankrupt, they get nothing. And so there is evidence, this is U.S. Congress, there's the evidence that it's owned by the Roman cult and those spacious that are there. Okay, so what's a fasci? Fasci has to do with fascism, first of all. Had its origin with the Etruscan civilization, was passed on to ancient Rome, where it symbolized the magistrate's power and jurisdiction. It is present on the older design of Mercury diamond behind the podium in the U.S. House of Representatives. Okay, and so this is all evidence that the Roman cult owns the United States. The symbolism of the fasces suggested strength through unity. A single rod is easily broken, while a bundle is very difficult to break. The axe represented a power of life over death. The fasci lictore symbolized power and authority, imperium in ancient Rome, beginning in the early Roman kingdom. The highest magistrate, the dictator, was entitled to 24 lictors. The axe indicated the magistrate's judicial powers included capital punishment. And we know the Roman emperors were real good at that, don't we? During the times of emergency, however, the Roman Republic might choose a dictator to lead for a limited time period, who was the only magistrate to be granted capital punishment authority within the pomerium. Lictors attending the dictator held the axes in their fasces, even inside the pomerium, a sign that the dictator had the power of ultimate power in his hands. And so, again, that's about the fasces, okay? So Congress is fascist. Fasces come from Rome and Roman law. Fasces represent penal power, plenary power. Fasces represent dictatorship by magistrate. Magistrate's the highest ranking official in the government, such as the king in a monarchy, the president in a republic, and the governor in a state. Also termed chief magistrate. A magistrate definition, too, can also be a local official. And so there's a bunch of Baal priest uniforms, okay? Right there's a bunch of Baal priest uniforms. The Roman cult, step 13, the Roman cult merges the bankrupt corporations. And this is taken from Congressional Record, August 19th, 1940, in the House of Representatives. And towards a British Union, a world state, international strife, okay? This is Congressional Record. And so then this is... let's see, I think I have the text here. Yes, it is. And so, Mr. Speaker, information contained in this booklet is important at this time, particularly in view of the fact that pro-English groups in the United States are now working in close cooperation with world internationalist organizations. Before 1917, world foreign influence came mainly from Anglo-American groups. Since the World War, these groups have been fortified by the international financiers and the internationalists, or the so-called minority group. The pressure is therefore more than double, for combined these groups control all avenues of communication, sounds like news media, and are now using them to further their plan of world domination to establish a world federation of states. And this is August 19th, 1940. That's the UN Charter was done in 1945. Let me call your attention to the fact that on the reverse of the Great Seal of the United States, which appears in our dollar bills, you will find the exact symbol of the British Israel World Federation movement. This symbol is also carried on literature and other organizations promoting a world government and a world religion. At the bottom of the circle surrounding the pyramid, you will find the wording Novus Ordo Seclorum. It was this new order that was advocated by Clinton Roosevelt several hundred years ago, recently Philip Drew, and now followed by the executive. That's the President of the United States, okay, in 1940. Step 14, convert court cases. So what they did is they obviously did merge the corporations, the UN. The U.S. became part of the UN, and so now it's owned and operated by the UN. Step 14, convert all court cases into commercial transactions. Convert a court case, convert an Article 3 judge into an Article 1 revenue officer. Bail priest clerk masquerading as a judge who's working for the crown and the Roman cult. Pay for the errors and omissions insurance. For the bail priest, so-called judge, they're by alleviating him of any responsibility in the matter, okay? And so this is all why this is filing fees does this. And makes it so that the bail priest, so-called judge, doesn't care what the outcome is, nullifies the bail priest's oath of office in the matter since all errors and omissions are covered by the insurance. I mean, why would he care? It's now covered by insurance. Converts the court case into a contract dispute in admiralty, makes it so the bail priest gets to collect a royalty in the case in support of his multi-million-dollar retirement. And there's Harvard Law Review articles about how most judges retire millionaires because of the admiralty court cases they administrate. Gives the bail priest a special motivation to dismiss the case, to thereby encourage more violations, to create more business down the road. Yeah, let's dismiss this thing so we can get some more business later. Create business for his bail priest buddies in the courts of appeals. Creates the opportunity to leverage the fees by 30 times since all courts are banks to improve the balance sheets of their so-called court. And generates revenue for the Roman cult handlers. Man, this thing is just a win-win situation. Step 15. Roman cult seizes control of all court cases and commercial transactions. And that's the Unidroit. All courts in Canada and the United States are United Nations courts under the Unidroit Treaty and have been for over 30 years. All courts are de facto courts. There's no authority to delegate anything to the United Nations in the Constitution for the United States of America or the British North America Act. Unidroit stands for Unification of Private Law, and the website says that 63 countries have adopted it. It's designed to be automatically implemented. Canada and the United States have been signatories for 30 years. Unidroit website says nothing about Texas, Arizona, or any of the American states or the Canadian provinces. Therefore, Unidroit application is in the American states and provinces is only in federal areas only, and it's actually international law because it cannot be internal. But again, remember we talked about how all state statutes are actually federal. Anyways, Unidroit covers negotiable instruments, civil procedures, secured transactions, legal status of women, maintenance obligations, contracts, banking law, much more. This is their website, and this is a little closer. And so then this is the next page of their website, and this is a little closer. You can see the header: leasing, security interests, transport, banking law, capital markets, civil procedure. Okay, all the courts. That's where courts come in. Contracts, general, okay, again, that comes into the courts. Cultural property, franchising, hotel keepers. Insurance, that affects the courts too because they're errors and omissions insurance. Intellectual property, leasing, legal status of women, that's definitely in the courts. Maintenance obligations, again, the courts. Movement of persons, negotiable instruments. And that's the courts because they want your negotiable instruments to pay the extortion. Covers mandatory insurance for motor vehicles, anything related to marriage, divorce, and children. This is taken from the Unidroit website, the International Institute for the Unification of Private Law, 1955 Benelux Treaty on compulsory insurance against civil liability and respect of motor vehicles. Why do you think it's mandatory to have insurance? 1958 Convention concerning the recognition and enforcement of decisions relating to maintenance obligations towards children. 1959 European Convention on Compulsory Insurance Against Civil Liability in Respect of Motor Vehicles, Council of Europe. And so all of this is on the Unidroit website. Oh, there it is close. And there's the membership. Okay, you see Australia, you see Canada, you see United Kingdom, you see United States. And there's a lot more there. They're all listed. And Texas isn't listed, Arizona, no American state, Alberta, British Columbia, Ontario, no Canadian provinces. Therefore, it's all commercial. It's got to be by contract. All judges are actually clerks masquerading as judges. Their black robe is their bail priest uniform. Remember we saw some bail priest uniform a minute ago? They routinely deny anything related to justice from happening because it's so good for business. They encourage their false flag operations and agent provocateurs because it's so good for business. They encourage police state murders, assaults, kidnappings, thefts because it's so good for business. Everything they do is a fraud and lie because they're Satanists. This is Tomlin's Law Dictionary. Again, it goes back to the Satanic Trust. Okay? And yet still it was found difficult to set bounds to ecclesiastical ingenuity. For when they were driven out of all their former holds, they devised a new method of conveyance by which lands were granted not to themselves directly, but to nominal fiefs to the use of the religious houses, thus distinguishing between the possession and the use and receiving of actual profits, while the season of the land remained in the nominal fief, who was held by the courts of equity, which is under the direction of the Roman cult, to be bound in conscience to account or tax his sestike use for the rents and emoluments of the estate. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing in 1835. And so this is all coming from the Roman cult. So step 16. The Roman cult makes all U.S. citizens into enemies. All U.S. court cases are warfare. Okay, that's all the Roman cult does is warfare. There's no peace. When you got the Roman cult in power, there's no peace. It's all warfare. Everything is warfare. A mixed war is one which is made on one side by public authority and the other by mere private persons. Okay, so a court case is warfare. Warfare generates revenue for the Roman cult. Warfare promotes the Roman cult agenda of population reduction. All warfare is a satanic religious ceremony. All bloodshed is a blood sacrifice to their god Baal. U.S. citizens are enemies of the state. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. See the so-called 14th Amendment in his unconstitutional video. A citizen of the United States is a civilly dead entity operating as co-trustee and co-beneficiary of the public charitable trust, the constructive sestike trust of the U.S. Inc. under the 14th Amendment, which upholds the debt of the USA and U.S. Inc. And that's a summary taken from Congressional Record, June 13, 1967, page 15641 through 15646. And so we're going back to the sestike trust here again, right? U.S. citizen equals Roman law equals Roman cult. Every taxpayer is a sestike trust having sufficient interest in preventing the abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. Slater's protestation that he derives no benefit from the United States government had no bearing on his legal obligation to pay income tax unless the defendant can establish that he's not a citizen of the United States. The IRS possesses authority to determine his federal tax liability. Okay, remember that goes back to the sestike trust and the rents and emoluments, right? They want to get their extortion. It's all a fraud. This is the DC Code. At Chapter 56, Section 1617, located at 31 Stat 1432, the legal estate to be in the sestike trust, sestike use. Okay, and this is more DC Code stuff. This is at 31 Stat 1189. This is right at the beginning. It says, be it further enacted in interpretation and construction of said code, the following rules shall be observed to, namely, that the word person shall be held to apply to partnerships and corporations. So again, it's all talking about the fictions. This is more DC Code, and in Section 117, that in addition to the jurisdiction conferred, this is located at 31 Stat 1208, in addition to the jurisdiction conferred in the preceding section, plenary jurisdiction, that's military dictatorship, people, is hereby given to the said court holding the special term to hear and determine all questions. And more DC Code stuff, and this is 31 Stat 1230. And Section 252, presumption of debt. If any person shall leave his domicile without any known intention of changing the same, and shall not return to be heard from for 7 years from the time of his so leaving, he shall be presumed to be dead. Okay, so that's where the sestike trust is. They just presume that you're a sestike trust. It's all part of their martial law scam. And if the Roman cult created the sestike trust, if the U.S. citizen's a sestike trust, and the Roman cult owns the U.S. citizen. If the legal estate in the United States is the sestike trust, and the Roman cult owns the United States. The Roman cult runs the so-called courts and wants to account or tax the rents and emoluments of their fraudulently created sestike trust. It's all coming from the Roman cult. This is DC Code again, located at 31 Stat 1265, citations. Okay, the court citations to owners. It's talking about condemnation of land for public use, said court holding a district court of the United States. And at Chapter 28, fees to officers and others, marshal fees, that for the service of any citation, summons, or capias. Well, Texas, they like to use capiases, that's for sure. Citation. Citation's a summons to appear, applied particularly to process in spiritual court. To the ecclesiastical courts proceeding court of the course of the civil and canon laws. Remember, we talked about that at the very beginning, how international law was split off from civil and canon law by citation and libel. And it goes through and talks about citations. That's Tomlin's Law Dictionary, 1835 edition. More stuff about citations. Ecclesiastical courts proceed according to civil and canon law. Tomlin's Law Dictionary. English ecclesiastical and probate divorce courts to call the defendant and respondent before them. And again, that's actually cited from Blackstone's commentaries, and it's taken from Black's Law Dictionary, 2nd edition. A tax, an impost, a tribute imposed on the subject, okay, the slave. An excise, tallage in public law. Taxation signifies a system for raising money for public purpose by compelling the payment by individuals of sums of money called taxes. General principles of taxation have been said to be that, number one, the subjects of every state ought to contribute to the support of the government. They ought to, but we just go and make them. And this is taken from Smith, The Wealth of Nations, okay? And it's taken from the Dictionary of English Law, Sweet and Maxwell, London, 1959. Declaration of Independence. He's combined with others to subject us to a jurisdiction foreign to our Constitution and acknowledged by our laws, giving us assent to their acts of pretended legislation. That's a fraud, okay? For imposing taxes on us without our consent. That's martial law. For depriving us in many cases of the benefits of trial by jury, okay? Again, that's all taken from the Declaration of Independence. The Declaration of Independence is really a list of grievances, and it's got martial law written all over it. Whereas taxation by the Parliament for the purpose of raising a revenue has been found by experience to occasion great uneasiness and disorders. Well, no joke, Batman, that from and after the passing of the Act of the King and Parliament of Great Britain will not impose any duty, tax, or assessment whatever payable on any of His Majesty's colonies, provinces, or plantations in North America, except such duties as may be expedient to impose for the regulation of commerce. And that's an act to impose taxes in commerce only, George III, Chapter 12, 1778. That's only 2 years after the Declaration of Independence. And you know, that's why it's 1778, 1867 was when they did the British North America Act. Well, they wanted to give Canada independence so then they can start extorting money from them again, okay? So then they couldn't say, well, this thing doesn't apply anymore, okay? And that's exactly what they've done. They're a bunch of thieves. All statutes are only for government property. This is actually a Canadian court case. Unemployment insurance, this is the Privy Council, so this is in England. This is as high as it gets in Canada. All statutes are only for government property. In other words, Dominion legislation, even though it deals with Dominion property. Okay, so all statutes, and it doesn't matter Canada, anywhere. It's the legislation only deals with government property. The Congress shall have power, this is Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting territory, other property belonging to the United States. Okay, so if you are a U.S. citizen, you are a slave. If you read any antebellum cases involving slavery, the debate was always over property rights. Again, antebellum meaning prior to the Civil War. The taxing power, being in its nature unlimited over the subjects within control, would enable the state governments to destroy the above-mentioned rights. This U.S. Supreme Court, Crandall versus Nevada, if they can take a penny, they can take it all. Okay? You are a slave. All subjects over which the sovereign power of the state extends are objects of taxation, but those over which it does not extend are exempt from taxation. This proposition may be pronounced as self-evident. It's obvious. The sovereignty of the state extends to everything which exists by its authority or permission. That's McCullough versus Maryland, 1819. For the very idea that one may be compelled to hold his life for the means of living or any material right essential to the enjoyment of life at the mere will of another seems to be intolerable in any free country where freedom prevails as being the essence of slavery itself. That's exactly what it is. U.S. Supreme Court. The privileges and immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the Constitution against the powers of the federal government. The only absolute and unqualified right of a United States citizen is to residence within the territorial boundaries of the United States. Civil rights under the 14th Amendment are for federal citizens and not state citizens. Federal citizens as parents have no right to the custody of their infant children except subject to the paramount right of the state. You're a U.S. citizen, it's Roman cult, and you have no rights. Capitis diminutio, meaning the diminishing of status through the use of capitalization. That's how they spell that, the Sestake trust name. In Roman law, okay, this is all Roman law. A distinguishing or abridgment of personality, a loss or curtailment of a man's status or aggregate of legal attributes and qualifications. Capitis diminutio maxima, meaning the maximum loss of status through the use of capitalization. That's the Sestake trust. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave. Black's Law Dictionary, 4th edition. This is the Commentaries of Gaius and the Rules of Ulpian, which is published back in like the 350 AD. It was translated with notes by this J.T. Abdi and Brian Walker in 1874. To take an instant, when a person sui juris has given himself an adoption, or a woman has passed under manus all their property in corporal, and all that is due to them is acquired by the adopting father or cooptionator, except those things which perish by capitis diminutio, of which kind are a usufruct. Okay, that's the Sestake trust. It's a usufruct. Sestake use. Remember, they call it a Sestake use. Well, a use is short for usufruct. An obligation to services on the part of freedmen contracted by oath and matters enforceable by a statute. And again, it comes back to the statutes only deal with government property. Classification of persons. This is Law of Persons by Joseph R. Long, published 1912. And the very first section, it says Roman law. Okay, so persons is Roman law. The loss of Section 3, the loss of freedom. A Roman citizen cannot legally be sold in slavery, but he might become a slave by condemnation for crime or by being captured by an enemy. And so, again, there you go. It's all slavery. Capitis diminutio is the destruction of the caput or legal personality. Capitis diminutio, so to speak, wipes out the former individual and puts a new one in his place. Between the old and new individual, there is, legally speaking, nothing in common. A juristic personality may be thus destroyed in one of three ways. Okay, so one is loss of status libertatis. That's capitis diminutio maxima. Number two is loss of status civitatis. That's capitis diminutio media. And so the point I want to make is that everything is about status. Okay, and under Roman civil law, status is everything. Under common law, status is nothing. And this is taken from a textbook of history of system in Roman private law, and it's cited in Black's Law Dictionary, 8th edition. Slavery is a status under Roman civil law, capitis diminutio maxima, the diminution of a person's legal status as a result of being reduced to slavery. And that's Black's Law Dictionary, 8th edition. Status, a condition, a situation. A corporation has no status as a citizen outside the jurisdiction where it was created. And so, think about it. A corporation's a citizen, therefore a citizen's a corporation. If they're assaulting you with a Sestake trust, which is a U.S. citizen slave, then you're in the United States. I don't care if you're in Texas. I don't care if you're in Arizona. I don't care where you are. If they're assaulting you with that Sestake trust, then you're in the United States. You're in the District of Columbia. And this is the Uniform Commercial Code, an act to enact the Uniform Commercial Code for the District of Columbia and for other purposes, located at 77 Stat 630, and in section 9.307, paragraph H, the United States is located in the District of Columbia. Okay, so again, if you're a U.S. citizen, you're in D.C. And this is more stuff about status. And the point here is Introduction to Roman Law, 1881, cited in Black's Law Dictionary, 8th edition, and it talks about different kinds of status. It's all Roman law. The law of status, the category of law dealing with personal and non-proprietary rights. It is one of three departments into which civil law is divided. Law of persons, the law relating to persons, the law that pertains to different statuses of persons. Okay, so again, it goes back to status. And that's Black's Law Dictionary, 8th edition. Both of those are Black's Law. With Roman cult civil law, status is everything. There's no real justice. Justice is for sale, depending on who you are. And it deals with statutes and corporations. With common law, status is nothing. It doesn't matter who you are. Everybody's treated the same. It's evident that they have not the political rights that are vested in citizens of the states. They are not constituents of any community in which vested any sovereign power of government. Their position takes more of the character of subjects than citizens. They are subject to the laws of the United States, but have no voice in its management. If they are allowed to make laws, the validity of these laws is derived from the sanction of a government in which they are not represented. Mere citizenship they may have, but the political rights of citizens they cannot enjoy. Okay, and this is talking about U.S. citizens, and the People versus De La Guerra, California court case, 1870. And so that's why they just, who cares what the election says, you know? I mean, it doesn't matter what the election does. The vote doesn't mean anything. You have to be a U.S. citizen to vote. The term citizen in the United States is analogous to the term subject in the common law, slave. Citizens can murder their unborn children. The unborn are not included in the definition of person as used in the 14th Amendment. It's that Roe v. Wade case. Citizenship is a political status and may be defined and privilege limited by Congress. The term resident and citizen of the United States is distinguished from a citizen of one of the several states in that the former is a special class of citizen created by Congress. Therefore, U.S. citizens residing in one of the states of the Union are classified as property and franchises of the federal government as an individual entity. Remember, it's a Sestakay Trust. A U.S. citizen, upon leaving the District of Columbia, becomes involved in interstate commerce. As a resident, does not have the common law right to travel of a citizen of one of the several states. Residents, as distinguished from citizens, are aliens who are permitted to take up a permanent abode in the country, being bound to the society by the reason of their dwelling in it. They are subject to its laws so long as they remain there, and being protected by it. They must defend it, although they do not enjoy all the rights of citizens. They have only certain privileges, which the law or custom gives them. Permanent residents are those who have been given the right of perpetual residence. They are a sort of citizen of a less privileged character, and are subject to the society without enjoying all of its advantages. Their children succeed to their status, for the right of perpetual residence given them by the state passes to their children. So this is what a residence is a slave, okay? And it doesn't matter, you know, they call you a permanent resident or they even call you a U.S. citizen. That's all slavery. The Law of the Nations by Vattel, Book 1, Chapter 19, Section 213, page 87. One does not necessarily become a non-resident by absconding or absenting himself from his place of abode. Well, think about it. It's all in what you tell him, isn't it? Resident, the fact of being officially present, the statutory presence of an incumbent in a benefice, okay? So it's all commercial. It might be correctly said there's no such thing as a citizen of the United States. A citizen in any one of the states of the Union is held to being called a citizen of the United States, although technically and abstractly there is no such thing. At the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects, unless the African slaves among us may be so called, and have none to govern but themselves. The citizens of America are equal as fellow citizens and joint tenants in the sovereignty. And the reason I'm bringing up the stuff about the slaves is that if you're a subject, you are a slave, okay? I don't endorse or approve of racism in any way, and I think it's satanic. And but this is right here where it's saying it. A subject is a slave. The right to trial by jury in civil cases, guaranteed by the 7th Amendment, the right to bear arms, guaranteed by the 2nd Amendment, have been distinctly held not to be privileges and immunities as citizens of the United States, guaranteed by the 14th Amendment, against abridgment by the states, and in effect the same decision was made in respect to the guarantee against prosecution, except by indictment of a grand jury contained in the 5th Amendment, and in respect to the right to be confronted with witnesses contained in the 6th Amendment. U.S. citizens are slaves. They don't have any rights. The technical niceties of common law are not regarded. A jury does not figure ordinarily in the trial of an admiralty suit. The verdict of the jury merely advisory and may be disregarded by the court. Yeah, we're going to ignore that. The rules practiced may be altered whenever found to be inconvenient or like to embarrass the business of the court. Yeah, we're going to railroad this guy, so let's just forget about the rules. A court of admiralty acts upon equitable principles. Gee, that sounds like the Roman cult. A libel of information does not require all the technical precision of an indictment of common law. Nah, it doesn't matter. It doesn't matter what it says. If the allegations describe the offense, that's all that's necessary. If it's founded upon a statute, it's sufficient if it pursues the words of the law. And that's U.S. Supreme Court again. We therefore decline to overrule the opinion of Chief Justice Marshall. We hold that the District of Columbia is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district, okay, U.S. citizens, and those of the states are not included in the catalog of controversies over which Congress could give jurisdiction to the federal courts. I lost my spot. By virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District, Columbia, and through their plenary power, okay, that's military dictatorship, people, nothing nationally covers those citizens, even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. So this is talking about D.C. citizens, but it's I mean, if you're a U.S. citizen, you're in D.C. And that's National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, U.S. Supreme Court, 1948. International law rule. We already covered this. We'll cover it again. Adopted for areas under federal legislative jurisdiction. Federalizes state civil law, including common law. The rule serves to federalize not only the statutory, but the common law of the state. State and federal venue discussed. The civil laws effective in an area of exclusive federal jurisdiction are federal law, notwithstanding their derivation from state laws, and a cause arising under such laws may be brought in or removed to a federal district court under sections 1331 and 1441 of 28 U.S.C. And so again, this is taken from jurisdiction over federal areas within the states. A report of the Interdepartmental Committee for the Study of Jurisdiction over Federal Areas within the States, Part 2, a text of the Law of Legislative Jurisdiction, submitted to the Attorney General and transmitted to the President, June 1957, and it's taken from pages 158 through 165. So, you think any different in Canada? It absolutely isn't. Okay, the same thing exists in Canada. The charter adopted in 1982 refers to citizens of Canada. Okay, the courts have told us that the laws of Canada are federal laws. Citizens of Canada are federal citizens. Canadians include state citizens and federal citizens. This is the charter, talks about every citizen of Canada in Section 3, Section 6.1, 6.2, 23.1, 23.2, 23.3. It says, Section 3, every citizen of Canada has the right to vote in an election of members of the House of Commons or of a legislative assembly and to be qualified for membership therein. And that's in the Charter of so-called Rights and Freedoms. Then notwithstanding any of this charter or rights and freedoms referred to it, guaranteed equally to male and female persons. Okay, so again, that's all Sestake Trust. All statutes are only for government property, slaves. In other words, Dominion legislation, even though it deals with Dominion property. That's unemployment insurance. That's a Canadian case. So then step 17, I should say. Roman cult BAAL priests denied justice. And the true agenda of the Roman cult is lots of revenue and bloodshed, okay? That's all they do is warfare. That's everything they do. Everything is warfare. If it's commercial warfare, it's in the courts. It's all commerce is warfare. And a war like World War II or World War III, that's just a giant commercial transaction. They can't have anyone being free, so they simply send out their Satanist order followers to assault people, kidnap people, falsely imprison people, and murder people. If anybody's not involved in one of their so-called contracts, they assault them anyway and let them, and then deny them a remedy. Okay, that's exactly what these Satanists do. And there's a bunch of BAAL priests right there. Okay, that's the chief BAAL priests. And anybody that's wearing a military uniform is an agent of the Roman cult. Wearing a clerical dress or religious habit on the part of layfolk is liable to the same penalty on the part of the state as the misuse of military uniform. And that's Article 10 of the Concordat of 1933, which was signed between Hitler and the Roman cult. And it's all so-called governments are bankrupt and owned and operated by the Roman cult. At common law, a sheriff would have a star only, and a judge would wear a business suit. At common law, there is no uniform. This is all brought to you by the Roman cult. And this is the Lucifer worship, the Easter Vigil of 2012 at St. Peter's Basilica, okay? And this is actually a YouTube video, so you can go look it up yourself. And this is actually, there's a guy that's making a chant, and he's saying it in Latin, so they put it on the screen in Latin, and they give you the English translation. And it says, "I say, O Lucifer, will never be defeated. Christ is your son." Okay, so again, this is the Roman cult. Okay, And there you go. There's the false prophet, Satan's spawn, right there, okay? Pope claims you're not Christian if you own a gun. Well, he's not Christian, so how the heck does he know, okay? He's a Satanist. That's why he wants people to get rid of their guns, so then they can murder them wholesale and get away with it. That's exactly where he's going. There are two ways to conquer and enslave a nation. One is by sword, the other is by debt. In doing this, I shall have occasion incidentally to evince how true it is that states and governments were made for man, and at the same time how his creatures and servants at first deceived, next vilified, and at last oppressed their master and maker. Let a state be considered as subordinate to the people, and everything else be subordinate to the state. U.S. Supreme Court, that's like 1793. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. To secure these rights, governments were instituted among men, deriving their just powers from the consent of the governed. That whenever any form of government becomes destructive to these ends, it is the right of the people to alter or abolish it. But when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under utter absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security. And that's Declaration of Independence, 1776. It's about time, people, we started taking care of business here, because we have a tyranny. We have communists everywhere. If a nation expects to be ignorant and free in a state of civilization, it expects what never was and never will be. If tyranny and oppression come to this land, it will be in the guise of fighting a foreign enemy. Power and law are not synonymous. In truth, and frequently in opposition and irreconcilable. There is God's law, from which all equitable laws of man emerge, and from which men must live if they are not to die in oppression, chaos, and despair. Divorced from God's eternal and immutable law, established before the founding of the suns, man's power is evil, no matter the noble words with which it is employed, or the motives urged when enforcing it. Men of good will, mindful therefore of the law laid down by God, will oppose governments whose rule is by men, and if they wish to survive as a nation, they will destroy the government which attempts to adjudicate by the whim of venal judges. And that's Cicero. And we have nothing but venal judges everywhere. They're not even judges. They're clerks masquerading as judges. The business of the journalist is to destroy the truth, to lie outright, to pervert, to vilify, to fawn at the feet of mammon, to sell his country and his race for his daily bread. You know it and I know it. And what folly is this toasting an independent press? We are the tools and vassals of rich men behind the scenes. We are jumping jacks. They pull the strings and we dance. Our talents, our possibilities, our lives are all the property of other men. We are intellectual prostitutes. And that's John Swinton, former chief of staff, New York Times. If a man be found stealing any of his brethren of the children of Israel, and make merchandise of him, or selleth him, then that thief shall die. Thou shalt put evil away from among you. And through covetousness shall they with feigned words make merchandise of you, whose judgment now of a long time lingereth not, and their damnation slumbereth not. We the people need to start taking care of business. Ye are the father of the devil, and the lusts of your father you will do. He was a murderer from the beginning, and abode not in the truth, because there is no truth in him. When he speaketh a lie, he speaketh of his own, for he is a liar and the father of it. These Roman cult Satanists can do nothing but lie. This Roman cult Satanist right here, this one right here, how can you tell he's lying? His lips are moving. But the fearful and unbelieving and abominable and murderers and whoremongers and sorcerers and idolaters and all liars shall have their part in the lake which burneth with fire and brimstone, which is the second death. If you're afraid to say something, if you're afraid to do something, then you're not going to do too well on Judgment Day. I'm sorry. By which also he went and preached to the spirits in prison. It shall come to pass in that day the Lord shall punish the host of the high ones that are on high, and the kings of the earth upon the earth, and they shall be gathered together as prisoners are gathered in the pit. And they shall be shut up in prison, and after many days shall they be visited. They're all going to hell. That's spirit prison's hell. It behooves every man who values liberty of conscience for himself to resist invasions of it in the case of others, or their case may, by change of circumstances, become his own. So what Thomas Jefferson is saying, he's talking about karma, okay, and about what goes around comes around. That's just another word for karma, or another phrase. And so this is my effort to make sure that, or at least to try and make sure that I don't get any karma coming around. And if you love wealth better than liberty, the tranquility of servitude better than the animating contest of freedom, go home from us in peace. We ask not your counsel or arms. Crouch down and lick the hands which feed you. May your chains set lightly upon you, and may our posterity forget that you were ever our countrymen. And that's, nobody could say it better than Samuel Adams. When shall it be said in any country of the world, my poor are happy, neither ignorance or distress is to be found among them. My jails are empty of prisoners, my streets of beggars, the aged are not in want. The tax is not oppressive, the rational world is my friend, because I am friend of its happiness. When these things can be said, then may that country boast of its constitution and government. Well, we have nothing to boast about here. We have a gang of criminals in the government, thieves and murderers and traitors. And the prisoners are getting populated everywhere. We have order followers all over the place running around populating the prisons. The streets are full of beggars. The taxes are oppressive. It's a tyranny. And we, the people, need to put a stop to it. But if the watchmen see the sword come and blow not the trumpet, and the people be not warned, if the sword come and take any person from among them, he is taken in his iniquity. But his blood will I require at the watchman's hands. This is my effort to make sure that I'm blameless on Judgment Day. Either you're part of the problem or you're part of the solution. You're now a watchman. I hope you're blameless as well. But in order to be blameless, you're going to have to get off your backside and start taking care of business. Circulate this video far and wide. There's one way that you can do it. You don't have to do it that way. There's other videos. I got over 240 videos. Bankster Thieves 1, 2, and 3. Churchianity series. Bankrupt corporate so-called governments. Bar members 1, 2, and 3. Do it yourself. How not to volunteer for the selected service. Martial laws here. Do it yourself. No income tax. Do it yourself. No sales tax. Traffic stop. Free mail. Kangaroo courts. Copies of these documents can be found in my private group at Yahoo called Administrating Your Public Servants. I have YouTube videos that are videos of private information shares that show these and other court citations that are available for a donation. Donations to support this work are appreciated, but this last paragraph is for all the Satanist revenue officers operating in their private capacity because they can put their privileges and benefits up their rectal orifice. I prefer a gold or silver coin, but as an extremely less desirable alternative, I can accept their IOUs, Federal Reserve notes, PayPal gifts, checks, money orders, etc. Send me an email for particulars. If you find this useful, you need to pay it forward. If you don't know what pay it forward means, then watch the movie. Send me your success stories. My blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email is engineerwin@yahoo. My YouTube profile is Sovereign Living. My Facebook community page, I deleted it because of censorship on the part of Facebook. My private group, Sovereignty International, is in the process of being deleted. My Yahoo private group is called Administrating Your Public Servants, and my Google private group is called Administrating Your Public Servants. I appreciate you taking the time to watch the video. I hope you got something out of it, and spread the word. We need to put a stop to this tyranny. And meanwhile, I hope you have a real nice day.